You know, I think Clement lowered the seat this morning. Where is that? I feel like a 5-year-old. Children's table. Oh, that's much better. Sorry about that. Good afternoon. We are happy to have you here today. Probably happier to have you than you are to be here. We are particularly happy to have Judge Karma McGee here joining us. And we will hear the cases as they appear on the docket. And unless there's any announcements, seeing none, would you please call the first case?
Holzmer versus the estate of James F. Walsh, Jr.
Okay. Whenever you're ready.
May it please the court, my name's Eddie Schmidt. I'm the lawyer for Ms. Holzmer, the appellant in this case. The appellate issue before the court is the proof required for the admission into evidence medical treatment bills of a personal injury plaintiff in a trial. During the trial of this case, we offered the testimony of Ms. Holzmer's treating doctor that her treatment was necessary. We separately offered testimony that the cost of her treatment was reasonable.
Now, is this the entire cost of her treatment or just part of the cost? 'Cause I noticed that doctor, at least in one of the briefs, I think Dr. Anderson maybe had testified his costs were necessary and reasonable. Is that right?
Yes, sir.
So which costs are we talking about? All of them, or just the hospital or surgery center costs, or what?
The trial judge excluded all of the cost we offered into evidence.
Okay, so
That's
all.
some $90,000. None of the costs were admitted into evidence. The jury never saw any of those.
Okay.
Counsel, did the doctor testify as to all of the medical procedures being necessary in this case, or just some subset of the medical procedures being necessary in this case?
Well, Dr. Anderson was a physician who testified on behalf of Ms. Holzmer. He's an orthopedist at TOA. And there was some treatment that was rendered by a physician's assistant before Dr. Anderson took over personally. However, that physician's assistant was being supervised by Dr. Anderson.
And did Dr. Anderson testify that the procedures done by the physician's assistant were necessary?
Well, I didn't go through each individual examination, but I asked him the umbrella question as to whether all of the treatment prescribed by him or on behalf of him was reasonable and necessary, and he said yes.
And you would include the treatment by the physician's assistant as
Yes,
part
sir.
of that question and answer?
And there was no objection during the trial that there was insufficient evidence or insufficient proof of that. The reason why the trial judge excluded the medical costs is because the trial judge indicated that there was no testimony that the billing was quote unquote necessary. All right, now during the trial, the appellee made several objections that it kind of evolved. I mean, first they said it wasn't necessary, then they said that it has to be in a physician, then they had another objection that, you know, if a layperson testifies, they have to testify that they're aware of the expenses of the area. Nonetheless, Judge Binkley excluded the cost because there was no proof that the expenses were quote unquote necessary. And in doing so, I submit, with all due respect to Judge Binkley, who I respect enormously, he applied an incorrect legal standard that caused manifest error, that was resulting manifest error and prejudicial error to the plaintiff. The appellee cannot and will not cite a single appellate decision in this state in which medical expenses were excluded from evidence on the sole basis that there was no evidence that the billing was necessary. And in fact, There are 3 appellate decisions in which that very argument was made and were rejected by the appellate court. That's the Spearman decision, Hudson versus West Monroe, and the Moneypenny versus Keeve case.
Before you get into those,
Yes,
let me
sir.
ask you a
Yes.
question. So, did the physician testify that the treatment itself was necessary?
Yes.
They just didn't testify that the billing was necessary?
Yes,
Is that
ma'am.
correct? All right,
That's
thank
correct.
you.
Now, where this conjunction comes from,
By billing, you mean the amount charged?
yes, sir.
Okay.
Yes. So where this conjunction comes from, that billing proof has to be that the billing or the medical treatment costs were both reasonable and necessary, comes from Borner versus Artry. That's where that terminology comes from. Borner versus Artry, and it's repeated all the time. In fact, it was even repeated in the Dedman opinion. And I submit, if you look at that opinion, the Borner opinion, the issue in that case was the interpretation and the application of the statutory presumption. That's TCA 24-5-113, subpart A. And that's the part where if a plaintiff attaches the bills to the complaint and they're under $4,000 or they don't exceed $4,000, they can be considered a rebuttable presumption that they are reasonable and necessary. Okay? And that's what the Borner versus Artry repeated.
Did anybody try and use did you try and use the rebuttable presumptions?
In this case?
In this case?
No, sir. And here's why. We got a trial date approximately 82 days after the case management conference in which the trial date was given to us. So the rebuttable presumption was not an option for me. But nonetheless, I'm increasingly being met in cases in which I seek to have the rebuttable presumption by sending, the bills to opposing counsel way more than 90 days. I usually do 6 months before trial. And I'm always met with a challenge saying that they're going to rebut it at trial. So nonetheless, if I get that response, what I have to do is what I did in the Holzmer case and what I've done in the previous case. I've got to get lay testimony in order to establish that the medical billing is reasonable and necessary, because the reality is
Counsel, I have a question about that reasonableness side of it. Dawn White, I believe, is one of the witnesses that you had. A trial judge seemed to believe that Ms. White could not adequately testify as to the reasonableness of the charges based upon her limited knowledge of charges outside of her facility. With regard to Dawn White, those charges in particular, where's the error with that judgment? I mean, you're asserting there is one, but where's the error, not on the necessary side, but the reasonableness side with regard to the Dawn White testified as to charges?
that's based upon the trial court's application of the opinion of Garner versus Maxwell. Garner versus Maxwell was a 1961 case. It's a 60-year-old case. In which that case, I think there was an office manager who testified with regard to reasonableness of the bills. And on appeal, the defense objected at trial and on appeal that, number one, the person testifying with regard to reasonableness of the bills was not competent. And secondly, they objected to the failure to establish that the bills were necessary. Both arguments were rejected by the Maxwell court. I submit that the trial court's application of Maxwell in my trial was also an error, because that,
Counsel, what do you need to prove then to establish reasonableness? If it's not what are other people charging, what are general charges within the community, how do you prove reasonableness? What satisfies reasonableness?
Your Honor, that's an excellent question. And it's something I struggle with. I mean, this is an important decision that this court's going to be met with, because the reality is, these days, most medical providers, especially medical providers that are probably under 40 years old, or medical providers that are in a specialty like Dr. Anderson in this case, and all medical providers that are in a teaching hospital like Vanderbilt, have no earthly idea about the cost of their treatment.
The trial judge seems to have drawn a line with reasonableness between witnesses who could testify, I know what other places charge. The trial judge said that's enough for reasonableness, or seemed to be saying
Yeah.
that's enough for reasonableness. And a witness who said, I only know my facility.
Yes.
I don't know anything. Doesn't that seem like a pretty reasonable place to draw the line on reasonableness in terms of you're aware of charges other places or you're not aware of charges other places?
Well, Your Honor, the defense always has the option of presenting their own testimony, that the testimony presented by the plaintiff with regard to the reasonableness of medical expenses was in fact not reasonable. And in light of the Dedman decision that upheld the collateral source rule, that's happening more and more. Defenses are offering the testimony of medical code writers to challenge the face amount of medical billing. That's the reality these days. Judge Bennett, do you have a question?
Well, I was thinking about going back to what we were talking about initially, the test that you say the trial judge imposed about whether the amount charged was necessary. Is that adequately phrased?
Yes, sir.
If the amount is reasonable and there's testimony that if there's testimony that the amount is reasonable and there's testimony that the treatment was reasonable, why wouldn't the amount be sort of viewed as reasonable? You need the treatment, and you need the amount, or the billing is said to be reasonable. Why isn't it therefore necessary?
I agree with you completely, Judge. And several of the opinions, I think in Moneypenny and in Spearman, make that same point. It logically doesn't make any sense. If treatment is necessary and there's separate proof that the charge of that treatment was reasonable, what's the purpose of establishing that billing is necessary?
Okay.
The appellee also makes an argument that the plaintiff's proof that the billing was reasonable was inadequate because it didn't come from a medical provider. As I alluded to earlier, in these days and ages, medical providers generally don't understand or don't know or are not aware of the charges. I deposed a urologist yesterday at Vanderbilt who performed a 6-hour surgery on my client. At the end of the deposition, I asked this physician, who's a highly educated doctor, are you familiar with the charges that Vanderbilt sends out for your medical services? He said, I have absolutely no idea. And that's a common refrain. That's exactly what Dr. Anderson told me in my meeting with him before the deposition the next day that we played at trial. I said, Dr. Anderson, do you know what TOA charges for your services? No, I have no earthly idea. You're going to have to ask the billing department. That's why I brought the billing department director to trial, because I didn't have the benefit of the presumption. And even if I had the benefit of the presumption, if the defense indicated that they were going to rebut that presumption, it was incumbent on the plaintiff, me, through their counsel, to put on proof. And that's what I did at this trial, and that's what I've done in other cases. Your Honor, I would like to reserve the rest of my time.
Well,
Yes, sir.
how much time's left?
I have 2 minutes and 15 seconds.
Okay, we'll let you reserve your 2 minutes. You're supposed to say that at the beginning.
Oh,
but
okay. I
so she
apologize.
can program that in, but we'll let you do that.
All right, thank
2
you.
minutes.
Thank you, Judge Bennett. Your Honors, may it please the Court. My name is Emmy Kennard, and I have the honor to appear before you all today on behalf of the estate of James Walsh, Jr., the appellee in this matter. Your Honors, this Court should affirm the trial court's ruling to exclude the appellant's medical evidence for two reasons. First, the trial court properly ruled that there was no competent proof to establish the causal link between the treatment that the appellant received and her alleged injuries. And second, even if there was sufficient proof on the issue of necessity, appellant failed to prove that her medical expenses were reasonable. Now, appellant asks this court today to find that her case vaults over the high bar that is set to overturn a trial court's discretionary ruling on the admissibility of evidence. Now, here the appellant proceeded to trial without availing herself of the statutory presumptions provided in TCA 245113, without competent proof on the necessity of all aspects of care that she received in connection with this accident, and without competent proof that the bills that she incurred had a reasonable value.
Okay, what about the doctor's testimony that the medical treatment that he performed and also prescribed for Ms. Holzmer was both reasonable and necessary?
Your Honor, I would like to ground the court by discussing the facts just briefly, and hopefully that will help answer your question. Now, there were 3 medical bills that were excluded by the trial court. There was medical bills incurred at the emergency department at St. Thomas. There was the Surgicare bills that were incurred through her shoulder surgery at St. Thomas Surgicare. And then there was Tennessee Orthopedic Alliance bills that were incurred over roughly a 2-year period. She initially saw a physician's assistant, Dr. Merriweather. She saw Dr. Anderson, her treating physician, for the first time in March of 2019, about a year after the accident. And then she went through another round of physical therapy for roughly a year after that. And those were all encompassed on the TOA bills. Now, the proof that the appellant offered to try to prove that these expenses were both reasonable and necessary comprised 5 separate and scattered links. One of those, as Your Honor mentioned, was Dr. Anderson's testimony that the treatment that he performed, prescribed, and ordered was reasonable and necessary. Dr. Anderson also testified that the emergency room department treatment that she received at St. Thomas was necessary. However, the appellant did not lay any foundation whatsoever for Dr. Anderson, an orthopedic surgeon, to satisfy the 4-part test that this court provided in Long v. Mattingly so that he could testify as to the reasonableness or necessity of that treatment by an emergency room physician. And Dr. Anderson also classified that emergency room treatment as an ER workup, an IV pain medication, and an anti-nausea. So that's the second sort of link that the appellant was attempting to use to piece all of these pieces together.
Counsel, was there an objection made on that basis at trial?
Yes, Your Honor. Initially, the appellant offered proof as to the reasonableness of the bills by each of the billing record custodians. And the appellee stood up at that point, objected, and the trial court said that he would reserve his ruling on the objection to listen to all the evidence to give the appellant the opportunity to have met both of those pieces of that burden. And so the trial court heard all of the testimony about reasonableness. He then listened to the entirety of Dr. Anderson's deposition, and at the end of that testimony, he ruled on 2 bases. First, Dr. Anderson had not satisfied the 4-part test to be required to testify about the reasonableness or necessity of the emergency room bills, and also that because Dr. Anderson didn't testify as to the necessity of any expenses in the case, that all of the medical expenses would be excluded. Now,
did the trial judge make that fine of a distinction between the different bills in this case?
No, Your Honor. After listening to all of these scattered pieces of proof, the trial court, in his discretion, determined that that bar for reasonableness and necessity had not been met, that he wouldn't allow the jury to be listening to try to piece together which medical records in the TOA records referred to Dr. Anderson as treating physician, which medical bills corresponded to those records, and then have someone who is a lay witness testify that those issues were related and that those were then related to the accident. Now, appellant had the opportunity during Dr. Anderson's deposition to lay a proper foundation for exactly what treatment he found was necessary, whether that included all of the physical therapy that the appellant had received prior to Dr. Anderson becoming involved in her care, whether that included the physical therapy afterwards, whether that included all of the emergency room treatment that she received, whether that included any of the ancillary services provided by St. Thomas Surgicare in connection with his shoulder surgery.
How, when one has testimony that the treatment is reasonable and the expenses were reasonable, how can it not be the expenses were necessary?
Your Honor, that's a good
The
question.
treatment was reasonable and necessary. I'll throw that in. It's a good question. Good.
It's a good question.
I was afraid I didn't understand, so I guess I do.
Your Honor, in Wilson versus Monroe County, this court explained what proof is required to show that medical expenses are necessary. And in Wilson versus Monroe County, this court said medical charges are necessary if there is a causal link between the treatment that's been provided and the original injury that was inflicted. Now, there are several examples for why just allowing medical expenses to be presented to a jury without competent expert proof can result in an issue where there are certain charges, certain expenses that were not necessary in the service of the treatment that was testified to be necessary. And I'd like to provide the court with 3 examples of these. First, you could have a situation where there's a mistake, where say at St. Thomas Surgicare, Dr. Anderson performed the shoulder surgery, he sealed the wound with a laser method, and yet then we have the billing record which shows that staples were charged in the service of that procedure. Well, those staples aren't medically necessary if the procedure involved lasering the wound shut. That would be a mistake on the billing, and you need an expert to look at that bill and see whether that charge for staples was necessary for the overall treatment. A second example, this requiring that there be something more in this causal link proving necessity of the expenses would prevent upcoding. For example, if you have a procedure that's been charged and coded as a very complex procedure, but that was a mistake, and the procedure was actually much shorter. A medical expert, one who was involved in the care or reviewed the records or in some way was aware of the difference between the complexities of various procedures, should be required to testify that those expenses for the upcharging were necessary for the course of treatment that was actually related to the original injuries.
Counsel, have you asserted that there are procedures on the billing that were not performed in this case?
Your Honor, the bills were never looked at by any physician whatsoever, and so there was no proof in the record that we could then rebut. Dr. Anderson explained prior to his deposition that he was not going to look at any medical evidence, but I will submit to Your Honor, as an example in this case, the ER treatment records, the bill which can be found as Trial Exhibit 4, it was a proffer. The ER treatment billing included a troponin test, an EKG, and an ECG. These are tests that are intended to determine whether a person has had a heart attack. Well, we would need an expert to say whether those tests are part of an ordinary ER workup, whether...
Counsel, but isn't that part of the treatment that the person is getting? I mean, if these tests are being performed, that's part of the treatment that he's receiving, and the doctor is saying that the treatment was necessary and appropriate, and that seems to cover it, doesn't it?
No, Your Honor, and here's why. Dr. Anderson's actual testimony was that the ER treatment included an ER workup, IV pain medication, and an anti-nausea. He at no point mentioned anything about testing whether a heart attack had been suffered by the appellant. And to provide another example, say a person goes to the emergency room after a motor vehicle accident. They're there, they're being treated for back pain and neck pain. While they're there, they separately have a diabetic attack, and so they receive various treatments to protect them against this diabetic attack. Well, there would need to be a physician testifying whether those expenses were necessary to the treatment of the injuries that she suffered in the car accident. And what the appellant has presented here are various pieces and links that...
Isn't that a question, though, for cross-examination? If the doctor says ER workup and you don't think that the checking to see if somebody has a heart attack is part of an ER workup, isn't that an appropriate thing to raise on cross-examination? Hasn't the doctor sort of covered it, and you can further narrow if you want?
Your Honor, here the appropriate foundation was not laid. Yes, it certainly could be considered on cross-examination, but here the plaintiff bears the burden of proving that these expenses were medically necessary and were reasonable in value. And because she didn't do that, there was nothing to rebut. The plaintiff bears the burden. It's not the defendant's burden to ask questions on cross-examination that open up the ability for the plaintiff to then go back and correct the proof and prove the case. This is the plaintiff's burden. This is a rudimentary requirement that has been stated by this court, by the Supreme Court, all the way back to 1987. It is always offered in the conjunctive that the treatment, the medical expenses must be both reasonable and necessary. And so another...
And the necessity, though, here, counsel, is the necessity of the treatment itself, right? There's not some special necessity of the bill is necessary. It's the treatment is necessary, and then is the bill reasonable? Or am I missing something there?
Your Honor, hopefully I can help explain this slightly better. I think that what you can see is that over the course of a certain prescribed treatment, there may be various different options of that treatment that could be charged. Now, sometimes it's a choice between two. And the expert can say, in this case, we closed the surgery with a laser. We didn't use staples. That charge was not necessary for this wound closure. And so that's where having...
But the wound closure is a form of treatment, is it not? And that's treatment. And if the doctor says that it was necessary, then the testimony is that procedure is necessary. So I'm still struggling to see what exactly this necessity is that's different than a doctor saying the procedures that were performed, the treatment that was received was necessary, where there's a distinction with necessity with billing. If the doctor says the closure method, the example you're using, was the appropriate treatment, was the necessary treatment, then put on an expert to say that it wasn't. But hasn't the plaintiff carried their burden of showing necessity?
No, Your Honor, they haven't carried their burden, not in this case, and not more generally in other cases. And I think really what this issue gets at is what is required to prove that causal link between the original injury inflicted and the treatment that was actually expensed to the plaintiff. Now, another example in this case, Your Honor, when the appellant put on proof of the Tennessee Orthopedic Alliance medical bills, those bills were proffered to the billing representative at TOA who looked through them, who said she was familiar with the billing. On cross-examination, she was asked whether she was familiar with the treatment that the appellant had actually received, whether she was familiar with the allegations in the lawsuit, whether she was there to testify that all of the bills that were being proffered were related to this original accident. And she said no, she hadn't reviewed the medical records. She wasn't aware of the appellant's diagnoses. And then upon cross-examination, it was determined that those bills included an ankle specialist, an x-ray for an ankle, a walking boot, treatment with a Dr. Korn, who she testified was a foot and ankle specialist.
The plaintiff conceded that wasn't part of the medical bills that were appropriately before the jury in this case, right?
Absolutely, Your Honor. Appellant's counsel is an upstanding member of the bar, and he said, Your Honor, we are not presenting those as proof in this case. But that should not be and cannot be the standard of proof that's required in Tennessee, that a layperson with no medical training stands up in open court and says, these expenses are related to the accident and these expenses are not related to the accident. And that would be an improper use of lay testimony to prove something that an expert is required to prove. Here, the plaintiff had various small links.
Counsel, if doctors don't know what the billing is, who's the expert you're supposed to bring in on the reasonableness of billing? If it's the doctor at Vanderbilt has no idea what Vanderbilt's billing, who do I call if I'm a plaintiff's lawyer to come in and testify as to the reasonableness of the billing, other than somebody involved in billing who's probably not going to be the physician?
Your Honor, there are several avenues for an appellant to present this evidence in a proper way. First, they could rely on the statutory presumption. They could call an IME doctor to come in and say, I specialize in looking at treatment records and looking at billing charges, and I can say that these billing charges were all incurred in the service of this treatment record. They can look at a medical record and say, here's the treating physician. He testified that the treatment that he prescribed and ordered and performed was necessary. Here's a billing record. It's got his name on it. Here are the charges. That corresponds to the medical record for the treatment that was provided. And so that person, that expert, can then create that link that was missing here. Your Honors, the dispositive issue here really is the trial court's ruling on the reasonableness. The appellant was clearly not putting on proof that was competent on that issue because the records custodians couldn't testify as to whether the treatment was customary.
Quick question on that. The trial judge only actually found for your client, though, as to Ms. White with regard to reasonableness, right? That's the only witness that only testimony gets kicked out based on reasonableness. The other two billing experts, I think the trial judge said, could go to the jury, but the problem was necessity, right?
Your Honor, yes, that's correct. Now, I will say the trial court ruled on Belinda Wood's testimony for Surgicare that she had sort of offered countervailing opinions, in one hand saying that she was familiar with customary treatment, and another hand saying that she was not. Your Honors, we would ask that this court affirm the trial court's decision. Thank you very much.
Thank you.
The appellee has raised for the first time two issues not addressed anywhere in their brief. First is causal link. Nowhere is that objection made, either at the trial level or in the brief. Secondly, this argument that there was an insufficient foundation with regard to the emergency room bills was not objected to at the trial level. Therefore, that objection is waived. Your Honor, I think what the appellee is asking this court to do is to change existing law and to put a burden on a plaintiff in a personal injury claim at trial to establish the admissibility of medical expenses. That's almost insurmountable. That's almost unfair. I mean, as this court asked before, who else is a plaintiff supposed to bring at trial if you can't get the statutory presumption for whatever reasons, and the provider doesn't have the requisite knowledge to testify with regard to the underlying charges?
Well, she said you have to find an expert who knows things about both, who's an expert in both. That would be fairly difficult, wouldn't it?
Well, in all candor, Your Honor, I have done that in the past with regard to a life care planner who testifies with regard to treatment costs in the future, and where there's a lot of different providers. I pay for the cost of that provider to testify with regard to reasonableness of the underlying charges. However, that's not practical in every case, and it puts a burden on the plaintiff that is unreasonable. I submit again, Your Honor, that the plaintiff sustained its burden of proof, that the trial judge's ruling excluding the medical expenses was an error for the wrong standard. Thank you.
Thank you. Thank you both. Very interesting and somewhat confusing topic. Thank you. Would you call